Yes.
Okay. Hi. I think my attorney is on Zoom as well.
No, he's not on Zoom. Why are you not here in court?
I was not able to get the time off, Judge.
All right. So here's the thing. You need to make sure that you appear in court, because otherwise your time off may be at the Bexar County Jail. You understand?
Yes, ma'am, I do.
All right. Can you see where her attorney is, Norma, and tell him he's needed back here?
Do you want me to text him, Judge? I have the assistance number.
Yes, if you would text him, that would be great. We're also calling him as well.
Okay.
2 very boring minutes later.
Pretrial services is requesting.
The information as far as the letter goes, Judge?
All of the information they needed. Has that been provided?
The only thing we talked about was, to my knowledge, about the letter. And I made an appointment for Monday for the PCP.
This is the turning point. The judge officially shuts it down. This conversation changes nothing. That's courtroom language for case closed, stop talking. It's a classic example of judicial control. Once a judge senses circular reasoning or emotional derailment, they cut the mic. The defendant's attorney even steps in to save her from digging a deeper hole.
But I was not approved for the time off. I was told that it was last minute and there was no hours available. So I rescheduled for Friday. That was the soonest they had, and that was when there was some time off available at my job. So I'm working on it, but I can't just provide a letter. I submitted the records, but the records you didn't accept. So I'm trying to do it as fast as possible, but there is a process, unfortunately.
All right. Well, they didn't accept the records because your records are from 2015, 2016.
Yes, ma'am. That was the last time that I seen.
So you can't present medical records saying this is my condition and it's from 2016. All right. So you're saying that your appointment is on the 21st. We're going to come back here on the, Ms. Ferguson, are we able to come back on the 24th?
Yes.
We're going to come back on the 24th. You need to be here. And you need to have provided all of that information to pretrial services. Otherwise, I'm going to make a decision on this non-compliance letter based upon whatever information I have. You understand?
What is a non-compliance letter?
Oh, the fact that you're not following through on your conditions of probation. Your conditions of bond. So we're coming back on October 24th, and you need to have all of that paperwork to them. If I get another report saying that they don't have all that paperwork, then I will go on this non-compliance letter based upon the information that I have. You understand?
Yes, ma'am.
All right.
Thank you, Judge.
You're welcome. Yes. Norma Botello is going to come back on the 24th.
Judge,
Here it comes.
am I able to speak?
Turn.
Yes.
She brings up her history with cancer.
So,
hoping the judge will soften.
I'm fine with coming on the
And
24th.
while that's heartbreaking,
I'll request
the
off.
courtroom
I'll talk to
doesn't
my
run on
boss.
sympathy. It runs on evidence.
But the PCP,
BOYD
it's just going to be establishing
draws the line.
care, because I honestly have not seen a doctor since 2016, since I turned 18. That was the last time I saw Cuomo. My conditions, they're not something that just go away. I have a history of cancer, and
It was at this moment that she knew. She fucked up.
these are conditions that I've been with for my whole life. And
All right.
that's
So here's the thing, Ms. Botello. You're telling me information that I have no documentation of.
But that's what the records were, Judge. That's what I was showing you, that I can go and pick up the records from pretrial and see exactly what's in there that says about my condition, but everything that I provided to her has that. And my conditions are from chemo and radiation.
All right, Ms. Botello, this is what you're asking the court to do. You're asking me to change what I'm requesting. You're asking me to change what pretrial services is requesting. And what I'm telling you is, you can continue to speak to me. I understand your issues. I've had family members who suffer from cancer, but you're on bond for driving while intoxicated with a child. Pretrial services has told you the information they need. I've told you the information that I need.
Yes.
And you're telling me right now Well, I still want to just give you the information from 2016. So I want
No.
to be clear. Well, let me be clear. You know what you need. You know what they're requesting. You know what I'm requesting.
Judge Boyd is laser focused here, and she's right. The defendant keeps submitting medical records from 2016, claiming they prove her condition today. That's nearly a decade-old document. In legal terms, that's like showing an expired passport at the airport and expecting to board. Pre-trial services need current proof, not a trip down memory lane.
So
Yes.
the conversation we're having right now is just a conversation we're having, but it's not going to change what I'm requesting and what they're requesting.
Right, but I'm trying to get at.
I would advise you not to continue this conversation. I can follow up with you after report.
Okay,
My advice to you at this time is to not continue this.
okay.
All right, thank you. Who's here on Edgar signs? All right, where's Botello?
She's right here, Judge.
Where are your documentations for probation?
So, Judge, we have the referral orders. She was able to go see a doc or PCP on Saturday. She has been referred to see a pulmonologist, but we do not have the letter that the court is requesting yet. The two pulmonologists that she has spoken to, the earliest that she can be seen for as a new patient is February. The other one that I've spoken to is her previous pulmonologist, and the earliest that she can be seen is December. What I would like to discuss with the court at this point would be alternatives with the breath test that she is currently ordered to have pre-trial. Ms. Botello is working, and we would accept an alternative such as the scram. However, the cost would be prohibitive for her. I don't know if the court is able to reduce the costs or waive some of the costs. We can,
I'll ask that the cost be waived. I'll place her on scram. She needs to provide that documentation to pretrial services.
we'll get that as soon as we can, Judge. I did discuss scram with the CLO. Apparently, there is a waiting period for scram devices, and we weren't sure how long that is. Once again, how the court like to handle that.
She is not to be taken off of the breathalyzer until she's on something.
Okay. We can also do UAs, Judge, if the court would prefer to have that. Her work schedule is Monday to Friday, 7 to 4. So if we can work with pretrial on that as an alternative.
What I'm going to do is the in-home breathalyzer on reduced levels until scram device is available.
Yes, Judge.
All right, is there anything else?
That'll be all.
Thank you.
Thank you, Judge.
Welcome back to Time Served, folks. Today's case? It's a wild ride. We've got a defendant charged with driving while intoxicated with a child in the car. Yes, with a child. And somehow she's the one complaining about being inconvenienced by court. Judge Boyd's patience? On thin ice. And by the end of this one, you'll see why he had zero tolerance for excuses.